Thanks for joining us, est-marie again. We're talking about the moving of assets to the detriment of creditors. So let's say you are in trouble. You want to move something out of your estate or out of the company that you might have or whatever, because you suspect that you might be declared insolvent in the not too distant future. There are creditors starting to sue you. You might be declared insolvent. Can you now move the assets away so that, for example, donate them to someone so that they cannot take those assets? And I think there was a recent case that shed some light on that.
Yes, no, you cannot just move assets away when you're in financial trouble, specifically not with the purpose of hiding it from creditors or preventing creditors from attaching that. I think a lot of people don't realize that, especially in marriages out of community of property, when people fall into financial trouble, they think that the marriage out of community of property is going to protect them, and they suddenly put everything in the wife's name without her purchasing it at the value. They just donate it essentially, and I think a lot of people don't know that if you then get sequestrated thereafter, that the trustee of your estate might go and take those assets back from your wife.
So donations between spouses, of course, do not attract donations tax, so you don't have that problem, but you might have the problem that those assets will then be attached by the curator if you declare insolvent. Is that right?
Yes, exactly.
So what do we learn from this court case? I don't think we need to maybe go into too much detail, but what is the lesson sort of?
This court case is actually from the Supreme Court of Appeal, which is very welcome at this stage because it gave clarity on the interpretation of what it means, the definition of disposition without value. So this is what we call, this is the term we use when people get rid of their assets shortly before sequestration. And there's been contradictory cases in the past as to what it means to say without value. So some cases in the past have said if you sell something at a discounted rate or below market value, then it can be regarded as disposition without value and the transaction can be set aside later. And then other cases have said no, it means no value means the ordinary meaning, no value. You got nothing for it in return. There must be something that you get for it in return. So the Supreme Court of Appeal in this recent case gave clarity to say the legislation, when this act was written in 1932, I think, did not intend for these words to mean anything other than the ordinary meaning. So disposition without value means no value at all. So in this case specifically, it related to a company, and they, before sequestration, a long time before liquidation, they sold certain shares to third parties at a significantly reduced price, probably because they were in financial distress and they needed the cash. And when they were liquidated, the liquidators tried to set aside these sales to say it was sold for no value because it was at such a reduced price. But the Supreme Court of Appeal then gave clarity on the situation to say no, there's nothing wrong with discounted transactions. The disposition without value means you got nothing in return. So it is a donation essentially that was done, and that can then be set aside.
Trusts are also, I guess, often used to protect assets, etc. And maybe, I don't know if you agree, this is also, again, a lesson that you can't just move something from your estate to a trust. There are obviously also cost implications, there are tax implications. But apart from that, if you have got some financial problems later, then a similar approach can be used by the curator of your insolvent estate to go and fetch those assets back from the trust. So it's not that simple. If you set up a trust now and you start building up assets legally and with no bad intentions in that trust, and you are maybe declared insolvent in 10 years' time, then I guess you're sort of safe. Then it's not a problem because everything was done properly. No problem with building up assets in a trust, but moving value out of your estate when you are in trouble, that's where the problem comes in. And there are certain sections in the Insolvency Act, like we saw in this case, which then assist the curator or the liquidator in the case of a company to go get those assets.
Yes, exactly. There's different scenarios or different sections that the curator or the liquidator can use. The one scenario was, in this case, the disposition without value. But there's other options available as well that relates to if you dispose of property with the intention of preferring one creditor over the other. That is one possibility. Or where you are colluding with a creditor or any other third party to defraud your creditors or prejudice your creditors. So those make it a little bit easier to get assets back in the disposition without any value. And then, of course, there is also the scenario of donating assets to your spouse or your children or future children in an antenuptial contract. So the Act also makes provision that if you make donations in your antenuptial contract and you get sequestrated within 2 years after registering the antenuptial contract, then those donations can also be set aside as a disposition without value.
Okay, makes sense. Thank you, est-marie.
Thank you.